Brian, if you want to get us rocking.
Whatever. Whatever you want me to do.
Wait. We got one more person. Ready? Thanks for tuning in on Facebook Live and YouTube. We appreciate you guys coming here today. We got my friend Jonathan Burns here to talk about trust and wills. We did run a little long in McMinnville on Tuesday, so we'll probably try to have Travis as well help answer some questions after, because he does have a tight schedule today. So, if you guys feel free to interact though. Go ahead, John.
Yeah, great. So, well, thank y'all for coming today. My name is Jonathan Burns. I'm an attorney at Spencer Fain up in Nashville. But happy to talk to you all about estate planning. And by all means, stop me as we go. Ask me questions as we go. You know, if anything doesn't make sense, or if there's anything you wanna know. But we'll talk. I guess, Brent, we'll start and talk about the differences in having a will, not having a will. You know, what that will accomplish for you. And then also the differences in wills versus trust, you know, and some specific types of trust as well, and the benefits that those, you know, can provide. So, in general, right, what can a will do for you that not having a will, you know, would result in? You know, a will is designed to say where your things go, right? If you don't have a will, then the state of Tennessee gets to decide, you know, who inherits your assets, and a lot of times it may be what you would have intended, but in some cases it's not. You know, in some cases it's not how you would have wanted things to play out. If you're married and you own assets in joint name with a spouse, when that first spouse passes, by operation of law, those would go to a surviving spouse. If you've got beneficiary designations for accounts, for example, like you have with Brent, or bank accounts, stuff like that, you know, those would go to whoever your beneficiary designation says.
And that's one thing that's really important too, because
Sure.
the beneficiary designation supersedes the will.
That's right.
So there was a great story last year where a gentleman had put his girlfriend on his 401k, I believe in 1988 or 1987. And he never married her, he married somebody else. And he had kids with this other lady.
Interesting, yeah.
The Supreme Court found that whenever he died, he had millions of dollars, so the money went to his girlfriend, ex-girlfriend. And the Supreme Court said, well, you put that down as your designation. That supersedes everything. So every time we check an account, you come in for an office, we want to check that designation, because, you know, if you've gotten divorced or if some things have changed, you want to make sure you change that very quickly. You know, because that will supersede any documents that are done.
That's right. And then thinking about, hey, what you might own that doesn't have a beneficiary designation that you might have just in your individual name. You know, not having a will if you pass and if you're married, those assets don't automatically go, you know, to a surviving spouse, right? It may be that if you have children, your children would inherit, you know, some of your assets if you're the first spouse to pass, which again may or may not be what your intentions would have been. So having a will, you know, at least even the most basic type of will, lets you decide who gets your stuff, you know, who inherits your assets, what's that structure for how they inherit your assets, you know, as well as who's in charge of that process, right? You don't have to worry about people potentially fighting and having arguments about who should be in charge, right? You get to decide, you know, through your documents, okay? So a will is the most basic, we'll call it, type of estate planning document where you get to decide who inherits your stuff, okay? There's differences, there's options though as far as what your main centerpiece document can look like, right? A will is one option, but there's also things called a trust that a person can use that can do the same type of thing, right? It can decide, or it can show, it can have the flow for who inherits your assets when you pass. And there's also other things that trust can accomplish for you, okay? So to walk through what those options are and kind of what that looks like, again, option one, we'll call it, is a will that says, hey, here's what happens to my stuff when I pass away, okay? Option two would be to have what we'll call a trust as the centerpiece of your plan that also can do those same type of things, right? It says that, hey, potentially, right, this trust says that whatever's inside of that trust, it's for my benefit now, okay, if I'm married, for me and my spouse, and then potentially for the surviving spouse when that first spouse passes. But then, right, it could play out, it could provide for that structure for how and who inherits, you know, ultimately, we'll call it children or other individuals. So at the end of the day, these type of documents can say the same thing, accomplish the same thing. It's just different how they get there and different what you can benefit from currently, okay? So with a will, The pro there, the benefit to having that approach, things are a little bit simpler. You know, it's not that it's difficult having a trust, but it's a little bit simpler with a will, because when you do that, you get your documents in place, and in essence, you're finished. Okay? Documents in place that says what happens when you pass, but you don't change title to your assets. You continue to own things like you own them currently. Okay? But to get your will effective and get your assets transferred where you want them to go when you pass, with the will approach, you've got to go through what's called probate to do so. Okay, so courts are involved, attorneys are involved, you know, things like that. I'll often get the comment where people were under the understanding that, hey, if I've got a will, I don't have to go through probate, right? I mean, that says what I need to happen, and I'm good to go. But your will is really not your will until the judge says so. Okay, so again, probate is a necessity to get a will effective and get your assets transferred to who you want those to inherit when you pass. Probate is all about transferring assets that are just in your individual name when you pass that don't have a beneficiary designation. Okay, so that would lead me into what I'll call general benefit number one of the trust approach, is that if you've got things owned by a trust, okay, then they're not technically owned by you when you pass away. Okay, so there's nothing that has to go through probate to get to who you want to inherit your assets. The trust says who gets those assets next. Okay, and so if we do all we're supposed to do under the trust approach, we can avoid attorneys, avoid courts, and things like that when a person passes away, because there's nothing that has to go through probate. Okay,
Because
so
the trust is a legal entity,
It
a
is.
legal person. So it's, you know, it can last for how many years in Tennessee?
So Tennessee, right, trust can last for 360 years, right, to keep things not only protected, as we'll talk about in just a second, protected for you, but also protected for those that you would like to inherit your assets down the way, right? But in general, you know, one of the benefits that we'll say a trust-based plan can provide us over a will-based plan is avoiding probate, you know, down the road. Another in general benefit of the trust approach as opposed to the will approach would, I would suggest, be more privacy for you, for what that's worth. You know, people being nosy, you're trying to look up where you live, what do you pay for your house, what's it worth, stuff like that. Under the will approach, where you continue to own your assets in your individual name, you know, it's really easy to go to the property assessor's website, you know, type somebody's name in and see what they've got, where they live, what they pay for the real estate, things like that. With the trust approach, we'll often not use your names as part of the name of the trust. You can call a trust whatever in the world you want to call the trust. And once we do that, and once we put your real estate inside of that type of vehicle, if anybody puts your name to the property assessor's website, nothing shows up. Okay, so more privacy now from people being nosy, you know, trying to see what you own from a real estate perspective. Also, I'd suggest to you more privacy later. You know, people being nosy want to know who inherited assets from you know, what the structure is for how they inherited those assets and things like that. Under the will approach, again, you've got to go through probate to get a will effective. Probate is a public record process. So anybody could go to the courthouse and say, well, hey, I want to see what that person did with their stuff. And they could get a copy of your will from the clerk and see what your will says. With the trust approach, again, one of our big goals is to avoid probate. You'll not have to mess with that process. And if we're not going through probate, there is no public record process. Even if we messed up, okay, when we go the trust approach, we'll still do what I'll call a just-in-case will, often called a pour-over will. It's really, again, there just in case we messed up and we missed something. We forgot to get a certain asset inside the trust or something along those lines, or beneficiary designation wasn't done properly. And so we had to go through probate just for that specific asset.
And that's the biggest thing, too, with trust. If you do a trust, you got to make sure that you title that property in the trust.
Right.
Right? So if you don't do that, and like you've said many times, consistently people don't do that step.
We've seen it several times, yeah.
They pay for the trust, they pay for the document, and they don't do the follow-up. And so that's the thing that if that's missed, then the will would say it goes into that trust.
Right. So you've got that short and sweet, again, what we'll often call that just-in-case will that says, well, hey, if I miss something, send it to the trust. Okay, but no details within that just-in-case will about who inherits, who's in charge, anything along those lines. So more privacy both now for real estate, but later down the road, from people being nosy about what happens and things like that. Yes, sir.
Push it back into the trust.
It does. So it controls, the pour-over only controls what didn't get in the trust already, right? What's still in your individual name that doesn't have the beneficiary designation that says where it otherwise goes. So a lot of times it might be, for example, Brent mentioned this just then. So when we do trust for clients, we quarterback that process or certainly oversee what we can handle, from a making sure things get where they're supposed to go perspective. And so when it comes to real estate, we're always drafting the deeds for clients to make sure their real estate gets inside the trust. But let's say we do all that And then 20 years later, they buy a new property and they forgot to have the trust buy it. And they bought it in their individual name and didn't think about putting it in the trust. And so they own that real estate in their individual name when they passed, right? So to get that asset that's in their individual name to the trust, some form of probate is necessary, right? So it's using that just in case will only for that specific asset to go through probate and get it there. You got it. You got it. That's it. So any type of trust can do those things for you. Any type of trust can help you avoid probate, give you more privacy. And I'll tell you, in a lot of states, I bet you that's where the conversation often stops. Okay, a lot of states it's, hey, the trust can do those things, avoid probate, give you privacy, but there's really nothing else a trust can do for you. Okay, but Tennessee is not like a lot of states. All right, Tennessee has some trust options that we'll talk about next, where in addition to avoiding probate, in addition to giving you privacy, we can do other things for you, give you additional benefits that we'll walk through with different options under Tennessee law. And we'll talk through, some of these trust options to an extent. Hey, it makes sense if you're in Tennessee or your stuff's in Tennessee, but some of these trust options are available not necessarily only to Tennessee residents or only to your Tennessee property, right? They could benefit you no matter where you live or potentially no matter where your assets are, right? So
Tennessee's become a state where a lot of trust companies have located.
Oh, yeah.
Because of law changes.
Oh, yeah.
It's become a state people just pretty much are involved here just for the tax benefits and these other benefits.
that's it. I mean, there's companies, there's, I guess, attorneys out there that rank states across the country about best places in which to form certain types of trust, and whether it be for asset protection, whether it be for longevity, whether it be for tax planning reasons or flexibility reasons and things like that. And Tennessee is typically around number 3 in the country about the best places in which to form a trust. Nevada and South Dakota are 2. They're typically first and second, but Tennessee's just right there on their heels about best places in which to form a trust. So the first one I'm going to throw at you, again, a Tennessee-specific type of trust. This one in particular, though, doesn't matter if you live here, doesn't matter if your assets are here. Okay, there is a Tennessee connection that I'll tell you about. All right, but it is one that's really available to people that just want to take advantage of Tennessee's trust laws. And it is focused on protection for capital gains tax avoidance down the road. Okay, capital gains tax avoidance down the road. This is a married couple trust option. Okay, we'll talk about a few married couple trust options. We'll talk about a trust option that's available to married couples and single individuals and all that. But let's start with this one. Again, focused on tax protection down the way. But let's say that we've got, this could be real estate, this could be investments, non-retirement investments, things like that, capital asset, okay? But let's make my math easy. Let's say that we've got an asset that's worth, let's say $500,000. Okay, it's worth $500,000 bucks. But let's say this is something, if it's real estate, something you bought a while back and it appreciated over time, or maybe it's stocks you bought and they appreciated over time. But let's say initially that purchase price for that asset was $200,000, right? So over time it appreciated to be worth $500,000. Most capital assets, right, if you decided to sell that asset, with our tax facts, you'll pay capital gains tax on the difference in what you sell it for and what you paid for it, right? The gain that you have there. So in our example right now, sold the asset before anybody passed away. We've got $300,000 of gain to pay, potentially, 20% or so capital gains tax on. Again, in our example, this is going to be an asset owned by a married couple. Okay, and right now, for where we'll start, there's no trust yet. Okay, this is just something owned in joint name between the married couple. What the IRS would say if this is a joint asset is that each spouse put in half. Okay, each spouse is attributed with contributing half of that purchase price. Okay. Then under current law, again, not in a trust yet, just how the tax code works. Okay, under current law, when a person passes away, the cost basis, what they paid for it, if you will, the cost basis they have in an asset when they pass, for tax purposes, gets an adjustment. Okay, gets what's called a step up in cost basis if that asset has appreciated, a step up in cost basis to whatever the interest that that person owns is worth upon their date of passing. Okay, so doing that math, we'll say the asset as a whole was worth $500,000 when that first spouse passed. That means that each spouse's 1/2 piece is worth $250,000. So when the first spouse passes, his or her piece of that cost basis gets that adjustment up to what it's worth. The surviving spouse gets that stepped up piece of cost basis added to his or her original portion. of the cost basis. So add those together. Now the surviving spouse has a cost basis of $350,000. Okay, so if after that first spouse passes, again, not in a trust yet, just how the typical tax laws work, surviving spouse decides, hey, I need to sell these stocks, I need to sell this real estate, whatever it may be, we've got less tax to pay, right? But there's still some gain there for which we would have to pay capital gains tax on.
And this is something we see even if you didn't do planning, when you inherit an asset when someone passed away, a lot of especially if it's a spouse, they forget to get appraisals on the property of what it's worth. And if you have rental property or other things that you want to depreciate or you want to do stuff with, it's really smart to go ahead and get that. You know, if you've got an asset you've had for a long time that you can not appreciate again, or equipment, it's huge.
Sure, oh, big time,
Big
time, right.
And so, and you want those, obviously, the higher the appraisal value for this purposes, the better, right? So usually one of the questions they asked the extension office was, why don't you just use the tax appraisal?
Right.
Well, most of the time, the tax appraisal in Coffee County is generally speaking lower than what it would sell for in the open market. So you really want to use a higher number. And it's good to have an appraisal too, because you have an independent person, if the IRS audits you, that's evaluated that number.
You got it. No, so that's how, again, I've said it several times now, but that's how things happen by normal operation, right? No trust yet, just a joint name between the spouses. So the first trust option to throw at you is what's called a Tennessee Community Property Trust, right? A Tennessee Community Property Trust. In any trust you put in place during your lifetime, you've got at least 3 roles. You've got what's called a grantor or grantors. Okay, that's who creates a trust. That's who puts their stuff inside of the trust. Okay, you've got what's called a trustee or trustees. Okay, that's who's in charge of what's going on inside the trust. And then you've got what's called a beneficiary or beneficiaries. Now, who's the stuff in the trust to be used for, right? So with this type of trust, again, married couple, we'll say husband and wife in our example, it's typically both for all 3. Both spouses form the trust, both spouses are in charge, both spouses are beneficiaries, right? So in a lot of cases, not really changing the dynamic whatsoever, of how things have been handled. This type of trust, like any type of trust, can help us avoid probate, can give us more privacy, right? But what it's focused on, what it does different than any other type of trust, again, is give the surviving spouse a capital gains tax benefit that he or she would not otherwise receive, okay? So the way this trust works, take our same hypothetical numbers, asset worth $500,000, cost basis of $200,000 while both spouses are living. If we've got this owned by a Tennessee Community Property Trust, instead of having this in just joint name between the spouses, when the first spouse passes, not only does the first deceased spouse's part get the step up, but the surviving spouse's part also gets that step up. And now the surviving spouse would have a full fair market value cost basis, right? So at that point, surviving spouse wants to sell that real estate, wants to sell those stocks, or like Brent mentioned, we've got commercial property or equipment, whatever it may be, right? We could redepreciate that now with this higher cost basis to offset the income we've got coming in. So with the right type of stuff, right, this can make a big difference for a surviving spouse. Give him or her flexibility, right? Where, hey, if I do want to do something different, I don't have to worry about, the tax
Also,
consequences.
it's an incentive to kill your spouse.
Say that again?
It's an incentive to kill your spouse, too.
I didn't say that. I didn't say that, but no, you got it.
But it is, so like in John, community property states automatically get this.
That's right.
And so like when I used to live in California, it was always, I kind of know now why all these 80-year-old guys are married to 20-year-old women. Because those women are pretty smart, because when they die, they get that step up, so they don't have to pay capital gains. They sell those beach houses. And so if they're still alive anymore, I mean, the houses are probably burned down now. But the point is, but the thing is, that's something that makes a big difference, for a married couple.
You got it. Right. Like Brent said, there's several states, I say several, there's 9. There's 9 states in the country that are automatically this way. You don't need a special type of trust to get this tax benefit, but there's only 9, right? Most states are not this way. Tennessee is one of 5 states, and Tennessee enacted this law back in 2010 to let married couples, in essence, opt into the special tax treatment that exists by default in those community property states, but in most states, it doesn't happen. So, right, again, Tennessee being progressive, like we've been talking about, being one of the prime states to create trust within, this is one of the great tools that we have at our disposal. This one, I would say, of the ones we'll talk about today, is the most flexible for, doesn't matter where you live, doesn't matter where your stuff is. Okay, it's all about this federal tax benefit that we're focused on there. Okay, our connection to Tennessee here is that while both spouses are living, we need at least one qualified trustee. Okay, a qualified trustee is a Tennessee resident or a corporate trust company qualified to do business here. Okay, so folks live in Tennessee, no problem, right? No issue whatsoever. We formed these trusts previously, though, for folks that have never set foot in Tennessee, don't have any assets in Tennessee, and that's fine. That's absolutely fine. What we'll do in that context, typically, though, is we'll pick what we'll call a token Tennessee trustee that's there to be a co-trustee with both spouses. Okay, we'll say that, hey, majority vote for all decisions, majority action to do anything you want to do. So really, it's still the married couple, right, that hold all the control. And then once that first spouse passes, we also typically say goodbye, to that Tennessee trustee because we don't need them any longer, right? The statute only says while both spouses are living. So, right, this one's been a great tool that we've had since 2010. Tax focus, again, protection from capital gains tax down the road is the name of the game with this one. So, stop there for a second. Any questions on this one so far? All right. So, again, protection.
It is a revocable trust.
So right. So
as
while both spouses are living, this is designed the way we'll typically draft it. It is a revocable, amendable trust, right? To change anything you want to change, take stuff out, put stuff in, no restrictions, even on paper. Okay. I'll tell you how I'll make it a little bit different in a second once we get past the next trust, as far as once that first spouse passes. But right, while both spouses are living, no restrictions, even on paper.
How do you get everything transferred over there?
Yeah, so typically the process, for example, with us, once we get, we'll call it pretty close, right, to being ready to sign documents and things like that, or maybe it's at the meeting when we sign documents, we go over again, what do we have? What are our assets, right? If it's real estate, then that's my job, right? We'll draft all the deeds that you'll sign that puts the real estate inside the trust. If it's financial investments, we're saying, hey, Brent, here's the trust is in place now. Get these set up to be owned by the trust, or if it's retirement accounts, hey, the ownership will stay like it is right now, but let's update the beneficiary designation at some point, right, to get into the trust. So, like Brent mentioned earlier, it doesn't make a lot of sense, to spend the money to do anything, especially the trust option, if we're not going to put stuff inside to get the benefits that it can give us. But right, that's a vital part of doing so.
But like also, one thing we haven't talked about yet in meetings is Jonathan puts in what's called a see-through trust provision in IRA assets. That way you still maintain the 10-year rule.
Right.
So the beneficiaries can pull money out. Currently, if you inherit an IRA, you have 10 years where you have to withdraw the money. The IRS is still supposed to give us a calculation on RMD percentage. They have not done that, to my knowledge, yet. It's been 3 years. We've been waiting for it. And so that also means you're not getting taxed higher because the trust is a beneficiary.
You got it. To kind of piggyback on that thought and kind of what we do with the retirement accounts, or in general what we do with these trusts, to kind of talk about it here. But even in this example, so right, we say beneficiary-wise, it's for both spouses. We say, hey, when the first spouse passes, let's say it continues on for the surviving spouse, and then when the surviving spouse passes, let's say, for example purposes, that this couple has 2 children. And so let's say they decide, hey, surviving spouse passes, we're going to split things equally, separate shares for each child. Our message to clients is that typically, and we're going to push you to not force the trust to have to stop at any point in time. Okay, our message is always going to be that, hey, these shares that you've got there that you want to allocate to your children, okay, don't give it to them directly, where it's now just in their pocket and it's viewed as their stuff. Let's have each child's share go into a separate trust that's just for that child. Okay, and if you're comfortable, if you're confident in your child that they can handle their own business, just let them be in control, right? Let that child be their own boss. Let that child be their own trustee, okay? But because this stuff that's now in this bucket for this child came from somebody else, right? It came from you. It's your stuff. It's not technically their stuff. It's somebody else's stuff in trust for somebody else. Once we get down to this level, even though that child can be in charge, right, be their own trustee, if they ever get sued for anything you can think of, creditors cannot touch what's inside of that trust because somebody else formed that trust for them. They didn't form it for themselves, okay? If it's in the trust, that means it's not being commingled with assets of the spouse. So you don't have to worry about a divorce ever touching that inheritance that you've left there, for that child, all right? So in general, that's what we're preaching, okay, to clients for how you leave things to a child, okay? Specifically talking about retirement accounts, though, okay? When it's your retirement account, state law says if you ever get sued, it can't be touched, right? Creditors cannot get to your retirement account, even if it's in your name, okay? If you leave it to your surviving spouse, they can roll it over, treat it as their own, and they get the same protection under state law, where if they ever get sued, your retirement account cannot be touched, okay? But when you leave your retirement account to a child, it's a different story, all right? An inherited retirement account is just viewed as another inherited asset. It's not viewed as their retirement account. And so if a child got sued and you named them directly as the beneficiary, the creditor could come after that inherited IRA. Okay, so typically, going back to kind of how we fund
Well, that's
things
one
in the
thing
trust.
that's actually happened. I know it's a big story, but O.J. Simpson, of course, his 401k was never able to be touched by any of the family members or anybody else. But when he died, because of the planning they did, I believe they've been able to
Maybe so.
actually get that money now, finally.
So what we'll do as it ties in here with the retirement accounts, for that we'll call it contingent beneficiary. Again, instead of saying it goes directly to a child, we'll say that instead that trust for the child is the beneficiary. Okay, and again, whatever their trust owns, whatever their trust is the beneficiary of, if they get sued, can't be touched, right? So, great question. It's a process, right? A lot of times thinking about specific assets, right? About what goes in the trust now, what goes in the trust later, maybe because for tax reasons we don't want to move it quite yet. But there's certainly a plan in place, right, for everything.
Do you recommend doing life insurance all into the trust or to the individuals?
You got it, same thing. So a little bit, I shouldn't say same thing, a little bit different. So retirement accounts, we typically don't get into the trust until we'll call it the surviving spouse passes. If there's a marriage, we don't do it until the surviving spouse passes. With life insurance, since you don't have the same income tax consequences like you do with retirement accounts, okay, we'll often say that, hey, the primary beneficiary of the life insurance could be the trust, right? So that we could also potentially protect the surviving spouse as well, just in case he or she got sued with those life insurance proceeds. Yeah, but it's a great question. It's a process thinking through, hey, what makes sense for this asset may not make sense for that asset.
Process for the trust creating follow-on trusts versus just keeping the trust. So, in other words, when the two spouses pass and the trust is no longer in effect, the trust is still there, but you're saying
You got it.
you put subsidiary trust.
That's, I mean, in essence, that's,
Having
yeah.
the initial trust have different beneficiaries.
Yeah, you got it. Great question. So there's potentially, we'll call it one trust agreement that exists for all the potential trusts that could be created going forward, right? So we'll get that question often saying, hey, once we get down here, do I need to do a new trust? Or do I have to do a new trust to do that? As far as a document goes, no. Okay, that same document that you put in place, it'll be the same document for many, many future generations, right? But it could be different trust instead of just one trust, right? We've got one trust that exists for both spouses. And to give you some of the tax stuff we'll talk about here in a second, this trust and this trust, we're typically designing it to use your social security number as its tax ID and keep things simple, okay? Once we get down to this level, which this would be a separate trust oftentimes, and that would be a separate trust oftentimes that have the same document, all right, but they are completely separate otherwise. And these two trusts would have separate tax IDs, right? They would have separate tax IDs and they're separate taxpayers for all purposes. So that's often the way we'll see things done. Not to say that we've also had instances where maybe just the client's plan was, hey, I want to keep everything in one pot, right? And just have multiple beneficiaries of that same pot for education or for medical expenses or whatever it may be. That could be a possibility as well.
I guess my question is how are those created? Does the executor create those?
So we'll have, great question. So we'll have what I'll call them, so under the will, right? If you're going through probate, you've got an executor, personal representative, stuff like that. With the trust approach, our goal is not to, right? But we'll often have, I'll often refer to it as a settle-up trustee, who it's their job to take that one pot that was there for the surviving spouse and fund those separate trusts for those children. Or again, if it's just one pot that continues on, continue on as the trustee of that. But you're right, it would be the settle-up trustee, their job to take that one pot, and I'm putting words and or making stuff up, right? But let's say the trust says, hey, 50% is allocated to each child, right? So it's their job to put 50% of the value in child one's trust and 50% of the value in child's two trust, which may be half of every asset, or it could be that, right, maybe this one child really wants this piece of real estate. We put all of that real estate in that child's bucket and put something of equivalent value in the other child's bucket, right? So that could be one or more people that serve in that role to settle things up, similar to what an executor would do in probate under a will.
But he did also make another point that was really good, I think, that with these trusts and the next trust he's probably most likely going to based on normal pattern, use your social security number. So for your tax returns, at least for you all, if you guys decide you want to do these types of trusts, you're not having to do a big thing with your accountant. It can be easy. You're not having to have 50 different trusts to run, and that's very important because from a practical standpoint, if you've got all these different trusts and all these different social security numbers or tax IDs, it can become very cumbersome, very expensive. So it is nice too that they flow underneath your social.
Sure.
You're saying the trust flows under your social?
It does, yes, sir.
It can.
Well, this guy, this role, we'll call it, the trust creators are living, right, that's when it flows under their social. Once we get down to here,
Right.
It can go into a different one.
right, they'll have their own tax IDs once we get down to the child level, we'll call it.
So property, life insurance, that kind of stuff. What about all the stuff?
Yeah, you got it, right.
What do you do with it?
Yeah, so we have, things that have a title, real estate, I shouldn't
I'm
say.
thinking more.
No, I'm with you. I'm with you. I'm going there. So with real estate, right, to get it in the trust, there's a formal process, right? You sign a deed and that officially moves it into the trust. But things like furniture, jewelry, clothing, things around the house, they don't have that title, right? This stuff.
Antique furniture.
So when we put a trust in place, we'll often sign a one-pager. I'll call it a Schedule A, but it's a paragraph that says, hey, everything I got, I'm moving into the trust. Right, so it's in essence our transfer document that says, well, hey, I'm transferring all of those things right now into the trust, so there's no need for probate to get those into the trust later. I've already signed this, we'll call it transfer document for things that don't have a title, okay? Within the trust, we'll often say that you could leave what's called a letter of instruction, or if you wanted to get specific about who you wanted to get certain personal property items, you could, right? But great question. There's things that we want to do to have that, we'll call it at the very least an argument to say, well, hey, I don't have to go through probate for my personal property items because I signed this document way back when to move those items into the trust. Cars are an asset we will typically not put into a trust. In Tennessee, they are easy to handle when a person passes with what's called an affidavit of inheritance that you can take to the DMV and say, well, hey, person passed away and here's who the new owner is and things like that. But yeah, that's typically how we'll handle what we'll call non-title assets like personal property.
What little piece of wheel is still left there?
So, the trust, right? The trust is going to provide for the ability for you to handle those things, right? Because the will, again, with the will, the issue there is, hey, to get it going,
You got to go through probate.
you got to go through
You
probate.
were saying there's still a will, that you probably still, even if you have a trust, you still have a will. to
We
take
do.
care of
We have
all that
one.
stuff.
We have one we hope we'll never need, right? But we have one that's just there in case. You got it. So this one, right? This type of trust focused on taxes, right? Focused on avoiding probate and privacy, but it's special deal. It's capital gains tax avoidance down the road. Okay. This trust is not focused on, hey, what if I get sued? What if somebody tries to come after me for something I did? That's not where the protection lies with this. Okay. With this type of trust, and we're going to rely on insurance, liability insurance, umbrella coverage, things like that to protect us in case we get sued. Okay, so to kind of walk you through, I guess you could say the negative or the downside with this one, just to compare to what otherwise, or how things happen in Tennessee. Right? Like Brent said, we're not a community property state. California is, there's 9 others in the country that are that way, but Tennessee is not that way. All right, what Tennessee is, for married couples that have property in joint name, that property, unless the ownership document says something different, it's owned by the married couple as tenants by the entirety property, okay? Not in a trust yet, just in joint name between spouses, but if the deed says, husband and wife, they're the owners, then you own it as tenants by the entirety property, okay? And that, in and of itself, not in a trust yet, gives you some benefit by default. It gives you a level of asset protection in case you got sued, okay? So let me walk you through what I mean by that. Let's say that husband is driving down the road, has a car wreck, and it's his fault. Okay, so creditor sues him, get a judgment against husband, all right, but the creditor cannot bring the wife into the lawsuit for any reason whatsoever. All right, such a judgment just against the husband, just one spouse. If that creditor can only sue the husband, that creditor cannot come after, cannot get to assets owned by that couple as tenants by the entirety property. Okay, a creditor has to be able to sue both spouses to get through their tenants by the entirety stuff. Okay, so again, not in trust yet, just in joint name. If the creditor can just sue one, can't touch tenants by the entirety property, right? Their hope, if they've got the judgment against husband, their hope is the wife passes away first. Okay, now husband owns that asset just in his individual name, which the creditor could come after. Okay, but while they're both living, they can just sue one, can't touch it, right? So if you have assets you own as tenants by the entirety property, and you move it into a Tennessee Community Property Trust, you are converting those assets to community property. Okay, community property does not protect the assets inside of that type of trust from the creditors of just one spouse. Okay, so if you have everything inside of that Tennessee Community Property Trust, in our example, husband gets sued, husband's 1/2 interest of what's inside of the Tennessee Community Property Trust is exposed to that creditor that can just sue him. Okay, so from an asset protection standpoint, hey, I want to protect my stuff in case I get sued, this type of trust is really worse than if you did nothing at all and just left things owned in joint name as tenants by the entirety property. Questions on any of that so far? Okay, so 2014 came along. The legislature in Tennessee recognized that there are general benefits to a trust. Okay, if you've got a trust, you can avoid probate, you can get more privacy. But if married couples wanted to form a trust up until that point, they were going to give up asset protection they had by not having a trust and just owning property in joint name as tenants by the entirety property. Okay, so in 2014, by law, by statute, we got what's called a Tennessee Tenants by the Entirety Trust, which you can imagine is more so focused on, hey, protecting assets in case there was a lawsuit. So the way it works, while both spouses are living, it's just the same as if there was no trust at all. Again, if the creditor can just sue one spouse, they can't touch what's in the trust. If the creditor can sue both spouses, that's when they could attack and come after what's in the trust. Okay, again, but if they can just sue one while they're both living, can't touch it. But the way the statute works, once that first spouse passes, we do get some better protection than we would if there was no trust. Okay? The way the statute works, when the first spouse passes, regardless of which spouse it is, regardless if it's the debtor spouse or the non-debtor spouse, the surviving spouse would be protected going forward, okay, from a pre-existing creditor of just one spouse, or if the surviving spouse got sued individually thereafter, creditors cannot touch what's inside the trust. Right? So more so focused on, hey, somebody trying to come after my stuff in case I got sued. Tax-wise, right, with this one though, to compare it to the first one, we're back to the normal rules that just the first deceased spouse's 1/2 is what gets that step up, not both halves, like the Community Property Trust. Yes, sir.
What was the name of that second?
The second one is called a Tennessee Tenants by the Entirety Trust. Yes, sir. Just kind of modeled after the type of property ownership. Yep.
I had some investments. But when I get the documents form, they say, tenants by the entirety on.
Great.
But they are in the trust. So does that mean they're part of the trust, or does that mean I need to change something?
So at some point, is there an account set up right in the name of the trust, right? What does that look like? So,
Just like if I get something from Schwab or whatever, it might say on there, tenants by the entirety.
Usually says tenants with joint rights of survivorship. WROS is how most of them are on there.
So I need to look at that.
Yeah.
look at that, because that's different, right? So if a married couple have an account set up with joint tenants with right of survivorship, that is joint tenants with right of survivorship. That is not tenants by the entirety,
But
okay?
like Florida, they really like in Florida they encourage. I don't know the reason why, but they're obviously some of the Morgan group or something you're talking about earlier, that they really encourage tenants with of entirety.
Yeah, yeah.
In Florida.
Florida's a state like us. There's 26 of the states have this type of ownership.
But a lot of
yeah.
car accidents, a lot of lawsuits.
Sure.
So I guess
Right.
that there must not be high limits on liability for injury like there is in Tennessee. There are some limits on what medical malpractice. There are limits now.
Yeah, yeah. But yeah, that's something to double check and make sure, right, that it's in the name of the trust. So these two, as far as structure, how they're formed, this one typically looks just like this one. Both spouses are grantors, trustees, beneficiaries, okay? This one does not have the same type of Tennessee trustee requirement that the community property trust does, okay? Its requirement is that when you put stuff into this trust, it has to be owned by the married couple as tenants by the entirety property before it goes in, okay? So, not that that's difficult. If you live in a tenants by the entirety state, we may have, we'll call it clients that for some reason, right, or maybe good reasons, had a property that was just owned by one spouse, okay? And so what we'll do when we put it inside of that trust, thinking through how we fund it, we'll go from just one spouse's name, put it in joint name first, and then from joint name, put it inside the trust, okay? But again, there's only 26 states in the country that are tenants by the entirety states, okay? The 9 community property states are not that way, okay? And so we'll have clients on occasion, I've had a couple of times, that have moved from Tennessee to Alabama, okay? Alabama is not a tenants by the entirety state, right? So in that state, it is not possible to own real estate as tenants by the entirety property, okay? They could still move property into a trust like this, that's still absolutely fine, but it wouldn't be protected from the creditors of just one spouse because they couldn't own that property beforehand as tenants by the entirety property. So with this one, right, where you live can make a difference whether or not it's an option to get the protection you're looking for, but again, don't have that same Tennessee trustee requirement.
If the trust was already established, couldn't the trust buy the property?
That's the thing. That's the strategy, right? We have the trust because it's the proceeds of funds. The way the statute works, it's the proceeds of funds that have that protection. And so our message to them is, okay, if you're going to move to Alabama, right, don't buy that property in your name first. Let's have the trust buy that property so that it would have that same. We at the very least have the argument for the protection. You got it. You got it. So these are very similar. As Brent mentioned earlier, both of these trusts, while both spouses are living, we will typically draft in to be revocable, amendable trust. But to get that, we'll call it absolute creditor protection completely for the tenants by the entirety trust once that first spouse passes. To get creditor protection up here for half the trust once that first spouse passes, okay? To structure things the best we can for what's called federal estate tax down the road once that first spouse passes. And I'd also add best we can to protect the plan, protect the structure that the married couple agreed to or put in place while they're both living going forward after that first spouse passes. Typically, we would draft these trusts upon the first spouse's death to at that point become irrevocable trust, okay? Practically, I've made a mess of it, but I'll erase it and show you. Practically, what that typically looks like, right, is that the surviving spouse is often the sole trustee, is often the sole beneficiary, right? So it's still all of your stuff, you're the one in charge, okay? But we say the right things on paper to give you that protection that we've been talking about.
But
Okay.
a lot of times when he does draft them, one of the things he has encouraged people to do is like, hey, if your spouse was dying and they might get remarried. And how many times do you hear they cut out your biological kids and they go to stepkids or whatever. So in that, you can make it to where there's a limited power.
There's often what you'll see there, right? So if surviving spouse is sole trustee, is sole beneficiary, if he or she is taking something out for himself or herself, that's fine. Okay, that's fine. If surviving spouse got remarried, as far as taking stuff out and spending on somebody else, that's when potentially the next in line could say, well, hey, mom or dad, I know the trust says it's for you, but if you want to start using it for somebody else, that's not okay, right? So some protection built in there, just if it's being used for, we'll call it a non-beneficiary, but then like Brent said, we'll often also give, even though it's irrevocable, we'll give the surviving spouse what's called a limited power of appointment, where if we need to make some changes, make some updates, what happens next, we still can, okay? Typically with the married couple context, it's not an unlimited amount of flexibility, okay? Maybe that, hey, surviving spouse, you can make some changes, but only in favor of our descendants and or charity, not you spouse, you family, and all that. It can be. I've certainly had ones where we have left that unlimited amount of flexibility, but oftentimes that's what we'll see, just like you said. Yep. Have time for the test?
Yes, we have
Yep.
time.
So
Definitely do test.
these two, again, very similar. It's just this one says, hey, we're taking advantage of this statute. It's all about taxes. This one says, hey, we're taking advantage of this statute. That's all about asset protection, protecting our assets in case somebody could sue just one spouse. One other trust, let me throw at you, is kind of a continuation of the thought down here about, hey, trying to protect my things in case something happened I didn't anticipate. Okay, if somebody tried to sue me, protecting my assets from that. So it is what is called a Tennessee investment services trust.
And for our purposes, like the Community Property Trust and the TIST are probably the most two popular trusts we work with.
Sure. And no, nothing special about the name. It's not just for investments. We'll certainly see it used for real estate and other type of assets as well. That's just what the legislature decided to call it in Tennessee. This one's actually our oldest. It's been around under Tennessee law since 2007, and it's different upon inception than the first two. Remember I told you with these two, while both spouses are living, this is a revocable, amendable trust. This type of trust upon inception has to be an irrevocable trust, right? Irrevocable, we'll talk about how that really operates. It sounds like, well, I can't make changes, it's locked in and things like that, but as we'll kind of walk through in a second, that's not really the case. Okay, for the amount of flexibility you can still build into this type of trust. Same type of players. What's called the grantor, right? That's the trust, the person who forms the trust, puts their assets inside the trust. A trustee, the person who's technically in charge of what's going on inside the trust. Then you got a beneficiary or beneficiaries. Okay, who's this stuff inside of the trust for? All right. The first two, community property trust, tenants by the entirety trust, those are married couple type of trust. You got to be a married couple to utilize those. Okay. This trust, the Tennessee Investment Services Trust, certainly married couples can use as well, but you don't have to be married to use this type of trust. Right? Single individuals can form a Tennessee Investment Services Trust. But to just follow with the structure we've been going with to show you how it can look, let's say it is a married couple that decide to utilize this type of strategy. Like those two, could have both spouses, we'll call it, as beneficiaries of the trust, right? But the statute says, to get the protection I'm going to walk you through next, right? The statute says that if you create a Tennessee Investment Services Trust, okay, you cannot technically be in charge as a trustee. Okay, so hypothetically, we could name both spouses as grantors, but if we do that, that means neither spouse could be a trustee. Okay, so what we typically do in the married couple context, we'll have one spouse be the grantor spouse, and then have the other spouse be the trustee spouse. Okay, so the way this type of trust works, again, the grantor is the one who forms the trust and puts the assets inside the trust. Whenever the grantor does so, the grantor signs what's called a qualified affidavit That affidavit says such things as, I'm not planning on filing bankruptcy. This doesn't make me insolvent. I'm not trying to defraud any creditors that exist right now, stuff like that. Put the asset in the trust, sign the affidavit, and provided a creditor cannot come along within the next 18 months after the asset goes in the trust and prove to a judge by clear and convincing evidence that, hey, judge, I am the reason, me, I'm the reason the grantor set this up, put the asset in the trust, right? Me specifically. I was knocking on the door, said, pay me my money, and the next day they formed this trust to get around me. All right, so they got to already be here. Absent there being a creditor, a pre-existing creditor that can make that proof, right, within that window, if the grantor gets sued individually for anything thereafter you can think of, that creditor cannot touch what's inside of that trust. Okay, no matter what it may be, whether it be something that happened by accident, whether it be something that happened intentionally, unless they are pre-existing.
Sorry, thanks.
Bless you. And come along within that
Too much
window.
pool time today, sorry.
Creditors cannot touch what's inside of that trust. Okay, and this trust, a little bit different than the other trust, can also give us protection, what we'll call from the bottom up. Okay, what I mean by that is, if we've got a piece of real estate, bless you.
It'll be like 50 in a row, I apologize.
If we've got a piece of real estate inside of a trust like this, if there's an accident at the property, right? Let's say there's a slip and fall at the property, and they want to sue the owner. Well, the owner is, this particular trust, and they cannot get past the trust walls to see what's outside or see what that grantor may otherwise own in their individual name or what they might have in a different trust. Okay, it's just what's in that particular trust that's exposed. So protection from a couple different angles with this one. Questions on that so far?
And that's a big thing too, like a lot of times, people do prenuptial agreements you recommend, and this agreement is nice because if you put the asset in there and later on, let's see, we get divorced, you can do this in your lifetime, it's not considered marital property.
There's certain, with this type of trust, there are certain, what we'll call, in different states have different ways, but there's certain what we'll call exception creditors, where how you can't protect against things like that, okay? Tennessee, their version, the only exception creditors are those if you fail to pay child support, you fail to pay alimony. And the spousal rights that otherwise could come in the way, if you will, from a divorce, only exist if it's what the statute defines as a current spouse when you created the trust, right? If you form one of these in advance, the way the statute is drafted, it is designed to at least protect what's inside, all right, from those claims of a divorcing spouse down the road, right? Not to say that the judge may take into consideration the value of what's in the trust, but they can't get to what's in the trust, if you will. So yeah, certainly if a prenup can't be done for whatever the reasons may be, this is certainly a good option to best protect what we've got in case things went south down the road.
And taxes, I guess, too.
Yeah, this one, like those first two, right, where the grantor's living, it uses the grantor social, right? Keeps things simple. All the income just flows through in your 1040, just like it does now. And I'll give you the step up, kind of how it works in just a second. But to give you some more color on this word, because again, initially that may sound like a bad thing, or sound like, hey, I'm giving up control, I'm giving up my access to what's in the trust, things like that. But to walk you through some flexibility that you still can have, with this type of trust. With any of these trusts, on the front end, you're going to say, well, here's what I think makes sense today, and here's what I think will make sense down the road, as time goes along, which would include, right, who's trustee, we'll call it number one, who is successor trustee, number one, who is successor trustee, number two, and you can make that list be as long as you want to make it as far as initial trustee and successor trustees, okay? Even though the grantor cannot serve in that capacity, cannot serve in that role, the statute does permit, even though the trust is irrevocable, to give the grantor the right to remove and replace the trustee at any point in time for any reason whatsoever, right? So if the trustee's not listening to you, not doing what you want to do, whatever it may be, you can still get rid of the trustee and pick somebody new to serve in that role. Even though the grantor can't serve as trustee, the grantor can serve as what's called the investment advisor for the trust. And the way we'll draft the trust, the trustee cannot buy or sell trust assets without direction and consent from the investment advisor, who is the grantor, right? The person who created this trust in the first place.
And the big benefit there, of course, is, you've got a separate person as your trustee, but they can't make any decisions without your approval.
Right.
So, that gives you liability protection, but you really haven't given up control.
Right. Right. Another piece of that control, if you will, is that right, you're also a beneficiary of the trust. And we'll often say that the beneficiaries can get distributions for their health, education, maintenance, or support. So you decide, hey, I've got this asset in the trust that I want to do something different with it. I want to take it out. Okay? So beneficiary says, hey, trustee, give me that asset. Just like we said, if the trustee says no, then they're not your trustee any longer, right? Because you'll kick them out and get to the next
Somebody
trustee.
do.
And get to the next trustee or get to somebody who'll do what you've asked them to do, right? So I know, I get that, I get it. Even though it's irrevocable, right? Even though it's got to look a certain way, the statute has a whole list of things that can still exist and flexibility you can still have that don't make it revocable and therefore lose the protection.
So your spouse, so if you pass away, your spouse becomes a guarantor.
So that role is
They can do
one.
anything they want to with it at that point, so whether you've got another set of kids or whatever.
They would be, so they would,
Not a lose situation.
No, because the grantor is the one person.
that role goes away, right? So that role, once the grantor passes, that role is only going to be, we'll call it one person. But the surviving spouse in this instance would oftentimes continue on as the sole trustee and the sole beneficiary. The thought would be, right, as far as, hey, if the surviving spouse, in this context, right, is the sole beneficiary, if the surviving spouse needed something for, in this example, for herself, right, she could take assets out of the trust, for her benefit. But this trust doesn't say it can go to the new spouse of surviving spouse, right? So if assets are being taken out for the benefit of the new spouse for surviving spouse, that's when the next in line could say, well, hey, in this example, Mom, that's not right? That's not what the trust says. Put it back. But if it's being used for the surviving spouse, in all of these contexts, that's absolutely fine.
That's only if they knew about it, though.
Yeah, I don't see how that works.
They have to
I mean,
know what
One
was coming
person's
out
in
of the
California or Denver or somewhere, and the other person's doing all that here, they're not even know it happened.
So if there's concerns about that, right?
You need a
and-
company as your trustee.
Yeah, if there's concerns about that, hey, something like that could happen, I want to make sure it doesn't happen. I don't want to give, we'll call it that, complete flexibility to the surviving spouse. Then maybe it makes sense to not let the surviving spouse be the sole trustee, right? Maybe have somebody be a co-trustee with the surviving spouse, or in some instances we've had somebody completely separate.
Or
right?
like
So-
even, another thing you can do on this is you can say, well, hey, when I die, a certain amount of money is going to my surviving spouse, a certain amount of money is going to my kid's trust, and that trust. You can separate that too. But having a good trustee or a trust company is really, really important, because none of these documents will work if that trustee doesn't do what you instruct them to do. So that's probably one of the best reasons to get an independent third party involved, to make sure what you wish happens. It does cost extra money,
Right.
right? So that's the downfall. But in my opinion, the more I go through stuff, it's very common for people to make mistakes. And having a trust company, if they make a mistake, if there's, you want to use a good trust company, we can sue them. They got to pay it out, right? Because they're the ones backing it, And so, and that's another thing too. And like in our situation here at the office, there's a pretty prominent financial institution 25 miles away from here, and they're the investment advisor, they're the trustee, and they're basically to make all the decisions. So it's a bank, right? So what does the bank think they should do with the money? Put it in CDs at their bank, right? Now, are they getting the best rate? No. And the charities they want to pick, they're not even following the rules in the document, because the document's public record. But guess who watches them? Themselves. You see, so obviously we're fiduciaries here, and so we like the fact that, hey, if we work with a situation, we're not going to be the trustee. We're not going to give ourselves that much power. Because if you give yourself too much power, there's a high likelihood you'll probably abuse it. So keep that independent. But having that trustee in the relationship, having a company, is usually a big benefit to make sure that what you want done is going to actually happen. You can do all these great plans, but if the person you pick gets addicted to cocaine and he spends all the money, you're going to sue somebody with zero balance, nothing to get. You don't see homeless people suing each other very much, right? They just go fight. So the point is That's why a trustee is really important, who you pick.
There you go. So all these, right? These are your canvas, right? So you get to decide how much, we'll call it flexibility, or how much restriction or control you want to give at any point in time, right?
Another
What
thing we
concerns
like to
you?
do too is also limit the percentage they can pull out a year to 5% of the account value. So if you got $2 million in the account, you can pull 100 grand a year out. If you don't need 100 grand, it stays in. But you're not pulling out all the money at once. It's really not good. I've got 7 kids, and it wouldn't be good to give them all the money right now. There'd be a lot of Legos, right? The whole room would be full of Legos. There'd be so many Legos they couldn't put them together. So the point is, that's not a really good use of the funds. So you do want to put some limits on that.
You got it. And then one other piece of flexibility for this type of trust, even though, again, it's irrevocable, again, on the front end, you'll say, well, here's what we think makes sense when both of us are gone, right? When the surviving spouse passes in this example. But even though the trust is irrevocable, we can give whoever the surviving spouse is, whether it be the grantor spouse or the trustee spouse, like we talked about over there, again, what's called a limited power of appointment, or if we need to make some changes down the road for what happens, what it looks like, things like that, we still absolutely can, right? Oftentimes, again, the flexibility here for married couple may be just, hey, our descendants and or charity. But if we draft these for single individuals, it may say, well, you can change this any way in the world you want to. Whoever you want the beneficiaries to be, that's up to you. Even though it's irrevocable, we can still make those type of changes. And then tax-wise, last thing I'll throw at you. Tax-wise with this, and compare it to the first two, same numbers. Let's say we've got an asset worth 500 grand, 200,000 of cost basis. With the first trust, the community property trust, remember with me, it didn't matter which spouse passed first, right? When the first spouse passed, full step up all the way to fair market value. With the tenants by the entirety trust, it did not matter which spouse passed first, but only our traditional half step up for the first deceased spouse's share. With the Tennessee Investment Services Trust, based on our structure, where there's one spouse who's grantor, one who's trustee, it does matter order of passing as far as cost basis step up is concerned, okay? Remember with me, contribution-wise to the trust came solely from the grantor spouse, okay? The trustee spouse technically did not put anything inside of the trust, right? And because of that, if the trustee spouse passes first, there's no cost basis adjustment whatsoever, okay? When the grantor spouse passes, since he or she put it all in the trust,
It's an immediate step up.
that's right, full step up all the way to fair market value, okay? So with this type of trust, it can make a difference on the structure about what the tax consequences are for that surviving spouse, okay? So what we'll often do here to diversify those risks, if you will, if we've got what we'll call potentially multiple types of assets, we've got some real estate, we've got investments, whatever it may be, we may have what we'll call trust number one that looks like this. In this example, husband's grantor, wife's trustee, but then we may have what we'll call Tennessee Investment Services Trust number two, grantor, trustee, beneficiary, where we flip-flop the roles, right? We have the wife be the grantor. That way we know we'll get a cost basis step up for at least something and when that first spouse passes away.
And usually when Jonathan's been doing this, most of our customers, if you're just making minor changes like names, those kind of things, you're not really changing the details, it's not costing you a ton of extra money to
Sure.
do multiple trusts.
You got it. I mean, for example, in these specifically, when we do one versus the other, one different strategy versus the other, if we do one trust here versus, in this example, two trusts here, there's not going to be any difference, from a call. It doesn't take us more time, if you will, to do something like that.
But the benefit of that too is you also have each property I own, like this building here or another office in McMinnville, they're owned in trust with different trusts, right? So from liability standpoint,
Yeah.
they've only got their liability to this one building.
Right.
And then my business is in a separate one. So, and my farm's in another one. So those four trusts act as a shelter for that asset on each asset.
If something happens here, none of those other assets are exposed. Right. That's what this trust can do different than those first two. There's no reason with those two to have multiple ones. Okay. There's no benefits you get by having multiple ones of those. Just like Brent's saying, here we could have separate trusts for separate assets to separate stuff from stuff. And when we do those, we go about it that strategy. We'll do these a lot for people that continue to buy real estate,
Right.
continue to have properties. And just like Brent was saying, once we figure out what version 1 looks like, it doesn't take us much time at all to give you version 2, 3, 4, 5, 20 that can look exactly the same. It just has a different trust name. It's a different trust, and therefore it's separate, from a liability.
But all this
perspective.
flows, again, through your social security number. So the benefit of that is you're not having to do 20 tax returns for 20 different properties. Because to make everything work, it's also got to be somewhat simple.
Sure.
Right? If you have too much complication, you won't follow the rules and it won't happen. So the idea that you can flow it all through, but you get the liability protection, and you can also put in some, restrictions on potential beneficiaries. I think those are some of the bigger benefits.
You got it. Questions and all that. Again, I know it's a lot to throw at you. Yes, ma'am.
Say you have to go into a nursing home, and you know how they come after the parents' home?
Yes, ma'am.
Would that prevent?
No. So none of what we talked about today would let you qualify in the first place. All right. So since these trusts we've talked about are you creating a trust for yourself, okay? The TennCare Medicaid, they're going to still see it as yours, right? And not see that it's gone from you, okay? I'll tell you this story, and I told Brent this and told others this. I had a client of mine, current client of mine, who's an attorney as well, but he told me that, hey, my dad set up one of these, right? Dad set up a TIST, put property, put assets in the TIST, and was able to qualify for TennCare, and they didn't come back after he passed away, okay? So I said, okay, that's interesting. So I looked at the rules, TennCare rules, and they say, well, hey, if you've got what is called a self-settled trust, one you form for yourself, again, we're still going to count it as yours, right? So I've got a contact at TennCare general counsel there, and I said, well, hey, client tells me this, but I look at your rules, and that doesn't seem to jive. I think this would still be yours, and therefore they'd say you've got too much stuff, and you wouldn't qualify for it on the front end. And he was like, well, yeah, that's pretty black and white. That's what it says, and that's how we would anticipate, we would interpret that as well. My anticipation is that the client thought this worked for that, and so they formed this, put the asset in the trust, and didn't disclose it whenever they went to apply, is my guess. I don't know, but that's my guess of what happened there. So to answer your question, right, when you're forming a trust for yourself, it's still your stuff in the eyes of TennCare.
But if someone else did trust for you, like if you had another person that gave you an asset via trust, would that still apply?
You could, right, so if it is parent forms a trust, again, not for themselves, but for child, right? Parent, you form it for somebody else, right, you could get it away from you, and if you can make it 5 years before you apply for TennCare, then right, they can't look back and see you gave it away, okay? Brent heard me say this the other day. I've been on the bad end of that, or seen the bad end of that on the back end. I've got one, didn't end up being a client because there wasn't anything I could do for them. But they reached out after the fact because they'd done that type of planning before, where mom and dad formed a gift trust, we'll call it, for children, okay, where they gave away the home, right? But before that 5-year window, expired, if you will, they needed to sell the home to take care of dad, right? He needed to turn in some cash to some money so that they could pay for the care. But the relationship they have with their children was not the same today as it was 2 or 3 years ago when they formed the trust, okay? And so my message was that, hey, your trust gave it away. You have no rights. You have no benefit from this trust. So, just talk to the kids, right? Tell the kids to sell the home, and then the ones in charge, just have them pay for the care. Kids weren't going to do that, right? They weren't on the same page with mom and dad any longer. And so unfortunately, right, what they had done couldn't be undone to make it right.
It's somebody else's.
Yeah.
Right? So
That's it.
You're basically saying, I'm giving them power over me.
That's it.
So there is, that's fine if they're, you'll realize what kind of person they are pretty quick.
And another, just finish there, another negative on that type of planning, we don't do a lot of it, but another negative on that type of planning, with all these trusts, we talked about cost basis step up, where, hey, when you inherit this asset, you get this new cost basis where you could sell things and not pay capital gains tax, okay? But when you give something away,
You get their cost basis, yeah.
kids will call it, take that cost basis. And then when mom and dad pass, there is no step up, right? They've still got the low cost basis that mom and dad had. So in the future, that's going to create a tax issue when the children need to sell the property, whether it be something in trust, whether they give it to you directly. We'll have clients who'll say, well, hey, I don't want to go through probate. I'm just going to give my home to the child, right? Let's miss probate that way. But again, when you do that, child takes your cost basis. They don't get a step up when mom and dad pass. If they want to sell it thereafter, now they've got a tax issue they otherwise could have avoided. if they kept it and kept it or put it in a trust or something along those lines.
What's your question, John?
In that terrible situation you were just describing where the father needed some care and the kids didn't want to stay
I'm
home.
doing pretty good.
If they had multiple trustees, then is it by committee or can one of the trustees say no?
You got it. So well,
So his question is, just for the thing is, if in the terrible situation where they did a gift trust, and could you have multiple trustees to make sure the right thing is done morally? Yeah.
couple thoughts there, right? So it depends on how you draft it, right? If you've got multiple trustees, you say how those trustees act together or not, right? It may be that, hey, you've got to have unanimous consent, or it's got to be, either can act alone, things like that. But you've still got restrictions on, hey, in this context, I believe it was children of the trustees, children of the beneficiaries. So you still couldn't give anything to mom or dad, right? Even if the trustees legally, technically wanted to, right? They would have to give it to kids, kids take it out of the trust, and then kids spend it on mom and dad, right? Hypothetically, and again, because the trustee did something different, they could be sued and come after because they didn't follow the rules. You got it. You got it.
But you'd have to leave one of your kids out because you got 4. So you wouldn't have a majority vote, John. You'd be out of luck. You still can, right? Well, that's Heather when I see her next time. So,
How often do you recommend that a trust be reviewed?
Great question.
question is, how often you recommend trust should be reviewed? Sorry
Yeah.
for people online.
I would say, from the client perspective, right, if things change, right, if I want to do things different for children, do something different with this property, or I've got new assets, whatever it may be, from the client perspective, that as often as that, something like that can happen, right? On our end, right, certainly for clients that we've done certain types of trust for, if the laws change, we're going to tell everybody that, hey, maybe we need to look at something different, right? For example, the previous administration, we talked about, cost basis step up and how that worked for all of these examples. The previous administration, floated the idea that, hey, let's get rid of cost basis step up. Let's don't have that, right? And if we get rid of cost basis step up, this trust goes away. There's no reason to use this trust any longer, right? So if something like that happened, then we're going to reach out to everybody we ever did one of these for and say, well, hey, we need to get together, right? There's other options we should do to think about that could, be better for our facts now. So I'd say, hey, client in, it's thinking about, hey, has things changed there, right? Certainly instances where, we've had a lot of these where, first spouse has passed away, right? And so it's not an instance like we would potentially have had with the will, potentially when the first spouse passes, where maybe is there something we have to do through probate. But it is often, talking about some questions and some tax planning we can do once that first spouse passes under any of these scenarios. And it may be a 5-minute conversation where we say, hey, all's good, nothing to do, or are there steps we could take, to put you in a better tax spot, going forward. Yeah.
Thank you.
Yeah.
I thought I was doing pretty good, but I got a little confused.
Yeah.
So if you get sick, so you put it all in a trust, you're going to know which one you picked, right, for different reasons.
Sure.
Then you get sick. So how do you figure out whether the trust is going to take care of you or not?
Yeah.
So the question asked was, if you get sick, is the trust going to take care of you or not? How do you figure it out?
Yeah, so I would say in all of these, what's in the trust is there to take care of you, right? Because in all of these trusts we've talked about, you are a beneficiary of the trust, right? But as far as, hey, can somebody else take care of me instead, right? Can I get the state? Can I get TennCare to pay for my care instead? As far as being able to qualify for that type of care, you got to have, we'll call it not a lot, pretty much nothing. And so whatever you've got inside of a trust like this, TennCare
You
is,
have to become not a beneficiary of it.
right, you're on it, yeah.
But like, that acronym health, education, maintenance, support,
You got to trust your
it's in there
support
too.
people,
Well, your trustee, whatever, but yeah.
You're right. But so as far as trying to get for TennCare,
Yeah.
you can't be in that bucket, right? You can't be in that bucket. And then you've got to be out of that bucket or not ever been in that bucket, we'll call it, for at least 5 years before you apply.
Well, and another part of that too is, as you look at the facts, right? The facts are, the baby boomers are one of the largest generations in American history to the millennials, but they're not much smaller than the millennials. And they're all retiring, right? Well, you can see where the healthcare system and Social Security are going to be taxed and not have enough money to reimburse the same facilities, right? And so when that occurs, people that can pay out of pocket typically are getting better care than people that are going into TennCare, right? So that's the thing to factor in, that You know, my grandma lived to be 101 years old, and she didn't have a lot of financial wherewithal, but she got pretty good health care because she's part of the greatest generation. Well, they had a lot of millennial, they had the, not millennials, the baby boomers. They had the baby boomer generation. Well, that generation, because it's like a pyramid scheme, right? Small group up here, big group paying taxes. Well, right now, if you look at the next 10 years, you know, you got a big group up here and a little bit bigger group down here, but not enough necessarily to pay. So you can definitely see a world where, for a lot of people in this room, where they're, you know, if you want to get a good doctor or you want to get special, you might have to start writing checks. We're already seeing that now with, you know, some prostate care where it'll take about a year for Medicaid to approve it, or you can write me a check for $4,000. Well, if you have prostate cancer, do you want it to fester for a year, or do you want to write a check for $4,000? I want to write a check for $4,000. You know, so that's just the, well, you know, that's the benefits are, you know, a lot of the TennCare stuff may not be as, and of course, if you look at the most recent House budget, what are some of the stuff they cut were those services. You know, it was just passed this week. So I think a lot of the Medicaid stuff, it's better to save enough money, of course, to self-insure, if you can, of course.
Other questions on any of that?
Well, thanks for your time, guys.
Yeah, thank you all for coming in. Yeah.
Of course. Thanks for tuning in too online. Oh yeah, please seek out competent legal advice for your unique situation before you make decisions. Call him. Thank you.
Let's be on the podcast.